Rise in the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning.
Good morning. Okay, good morning and welcome to the appeals court today. We've already heard 2 arguments on Zoom, so we're going to start now with our 3rd case. But before I call the case, I'm going to introduce the panel to you. To my right is Justice Eric Nyman. To my left is Justice Andrew D'Angelo, and my name is Ariane Buno. The next case we're going to hear is 2023-0314. And unlike the usual situation where each side gets 15 minutes, on this particular case we have a number of people arguing, different parties, and you're splitting your time. I'm assuming that you're all aware of the time that you're splitting, all right? And I'm assuming that the clerk, that our clerk is aware of that as well. I also want to remind everybody that this case is impounded, and so that we're not going to use any real names during the course of the argument. Okay? 2023-0314, Department of Children and Families and Others versus Child One and Others. Counselor?
Good morning, Your Honors. Tamika O'Brien on behalf of Mother. Your Honor, in this case, the issue that Mother would like to discuss today is that her waiver of counsel was not voluntary, unequivocal, knowing, or intelligent, and that the trial judge erroneously accepted her waiver without conducting an adequate colloquy. Your Honors, in this case, the trial judge should not have accepted Mother's waiver of counsel when, first, Mother really didn't understand how complex trial would be, and secondly, Mother's mental health rendered it impossible for her to knowingly, intelligently, and voluntarily waive her right to counsel. Here, it was the trial judge's obligation to ensure that Mother was adequately aware of the seriousness of the proceedings, the magnitude of the undertaking, and the disadvantages of self-representation. Your Honors, in this situation, the trial judge did give a colloquy 3 times.
Yeah.
Correct. And that...
Do you take issue with the content of any of the colloquies?
The content specifically, here's my issue. First, the fact that he did 3 colloquies indicated that he knew that there was a problem here.
I'm going to ask you to take a step back. I'm going to let you answer it the way you want to, but first I need an answer to my question, which is, do you take issue with the content legally of any of the 3 colloquies?
The issue I take with the content of the colloquies is it was boilerplate, and in this situation, a little more inquiry was required. The trial judge, from the beginning of this case, indicated Mother's mental health concerns. The court investigator raised concerns about Mother's mental health. The trial judge had trouble getting through the colloquies all 3 times. I think in this situation, I'm not saying that every single case where there's a mental health issue deserves a further inquiry. I think that we're all aware in these kind of cases, there's a lot of mental health issues. But in this case, in this specific case, I don't think it was too much of an ask to go a little bit further.
What would you have had the judge ask? Tell us with particularity and tell us what case requires it.
So I did not find well, there's adoption of Brianna, which is, I believe it's a 128 case. And the facts in that are a little bit different, but it's similar in the situation of the trial judge said, you know, in response to the trial judge's questions of, you know, you want to represent yourself, you know, Mother in this case, not unlike in Brianna, said, I think that the trial's going to be difficult, but I'll do it. Sure, I'll go do it. And every time she frequently was distracted and interrupted the trial judge to discuss, well, my previous attorneys committed this malpractice. There wasn't an indication that Mother really understood the seriousness of what was going on. And in this situation, given Mother's behaviors, calling DCF, having a loose grasp on the reality of her situation with her children, I don't think that it was too much to ask just for a few more questions. Do you understand what the rules of procedure are? How do you understand that? her saying, well, Judge, I've been studying the law since May, 5 or 6 months before the trial, isn't sufficient. And for the...
Even if she had answered, no, I don't understand the rules of procedure, that's not a requirement for somebody to represent themselves, is it?
It's not a requirement, no. But...
And didn't the judge also give her time he stopped the proceedings?
I'm sorry,
Give her
could you
time
repeat
to speak to her attorney outside the courtroom before bringing her back and restarting the colloquy.
Sure.
I think he did that twice.
Well, he did do that twice, but if you look back to the trial record, in this situation, the very first time that mother, quote-unquote, waived her right to anything, there was no waiver at all, which leads me to believe that the seriousness that this trial judge took with a waiver of counsel by basically putting her in a breakout room with her attorney to in a sense, get her attorney to conduct that competency evaluation of whether or not mother could waive her right to counsel, it raised some questions. Your Honor, I see my time has expired. If there's no further questions, mother asks that the termination of her parental rights be
I just
vacated.
have one final
Sure.
question, and maybe it's that Rule 23, but I'd prefer a published case. What is your best legal authority, and by authority I mean a published case, for the proposition that the judge here was obligated to do more? I'm having trouble finding one, but that doesn't mean it doesn't exist.
Your Honor, I believe that, and I don't have the site off the top of my head. I'm happy to file a 16L. But in my brief, I referred to a couple of cases, Holtzwinger, and also I think Means. And in those situations, the judge, the court found that there more was required to delve into the competency to waive.
Okay.
Thank you, Your Honors.
Thank you very much. Good morning.
Good morning. Good morning, Good morning, members of the panel. May it please the court, my name is Natalie Hoppel, and I represent the eldest appellant male child in this appeal. There are 4 siblings in this matter, 2 younger female sisters, and 2 older male brothers. I will be presenting argument today on behalf of my client as well as his younger brother. Your Honors, my client and his brother are requesting the court vacate the termination decree and return them to the permanent custody of the department. In support of their request, I'd like to focus on the lack of an adoption plan for the youngest brother and what can be considered a plan to make a plan for the older brother. While adoption plans are not prerequisites for termination, here we have a flawed but interested parent, the father, who was visiting the brothers up until the time of trial. Father's imperfect but upward trajectory, combined with the deficient and non-existent plans for these brothers, gives rise to an abuse of discretion that justifies reversal in this particular situation. Your Honors, it's well established that the severing of parental rights...
You're saying this justifies reversal just as to what?
As to the boys and the termination of father's parental rights. So we're
You want to reverse the termination of parental rights finding/ruling solely on the basis of the failure to have an adequate adoption plan?
No, Your Honor, I do not. I'm not asking that. I'm focusing on that particular aspect of our argument. I would argue that the cumulative error doctrine would pull in all of the errors together and the legal errors, and that would also justify a reversal. But I'm focusing today on behalf of the children on their adoption plans, not dispensing or waiving any of the other arguments that we have all brought together as co-appellants in this particular case. So I apologize if that clarifies. So, Your Honors, just going back to what I was saying is the severing of parental rights should not take place unless the children's present or future welfare demands it. Here, termination was not necessary for the brothers. With the presence of a flawed but interested parent who was visiting the boys up until the time of trial, the lower court had a viable option, which we're requesting, which was to commit the brothers to the permanent custody of the department. especially where the department was not able to produce concise or concrete adoption plans for both children. Then, if the department secured pre-adoptive homes for the boys, preferably together, given their strong bond, a review and redetermination could have been requested by the department. Also, placing the brothers in the permanent custody of the department would have permitted the lower court to exercise its oversight function to ensure that the department engaged in concurrent planning. The parental bond that existed between the father and the brothers should give this court pause. It's been stated, I believe it's an adoption of Flora, that our courts have expressed concern over terminating an unfit parent's rights where bond exists between a parent and child and where adoption is unlikely. And it would be the lack of the adoption plans and any plan that was concrete and readily apparent to the lower court judge that would support, again, what we're requesting, which was returning the children to the permanent custody of the department. Your Honors, as reflected in the brothers' amended supplemental record appendix, and it's at pages 58 and 59, the post-trial events, which are reflected, so I am somewhat going out of the record, but not entirely because it is in the record appendix. The post-trial events have not taken place with respect to the brothers, is in stark contrast with the actions of the trial judge in adoption of Jacob. Your Honors, in Jacob, the trial judge took extra steps without adoption plans to oversee the department's recruitment efforts. That has not happened, at least to the point at which the appendix notes what steps have taken in the lower court for these brothers. The judge in Jacob didn't wait 12 months for the mandatory review of the permanency plans. The lower court judge in Jacob retained jurisdiction, ordered the department to report to her every 30 days to enable her to closely monitor and assess the department's efforts and progress post-termination. And I would distinguish that particular case from this particular situation where these boys do not have concrete adoption plans. Again, it's a plan to make a plan, an adoption by recruitment, and with respect to the youngest male child, there was no plan in existence. Adoption plans are important. Child-specific aspects of termination matters that focus on the minors, their best interests, and whether they need ongoing contact with their biological parents should be reflected. The plans detail children's vital statistics, their age, health, development, personality, and personal characteristics. Again, Your Honor, I recognize my time is coming to a close. With that, I would ask the court return.
Just one more
Yes, Your
question.
Honor.
Thank you.
Thank you.
You raise one issue.
Yes.
I believe you argued on behalf of your clients that it was error for the judge to allow counsel for the father to withdraw.
Yes.
Do your clients have standing to make that argument, and if so, what authority do you have for that?
So, Your Honor, I would concede that traditionally under our approach to standing, they do not have standing, but I can, and I did look into a little bit of some Supreme Court cases, and I believe it was Kolowski versus Tesmer, which is 125 Supreme Court 567, and it discusses third-party standing, and it recognizes, and I'm quoting, there may be circumstances where it is necessary to grant a third-party standing to assert the rights of another. It's not looked favorably upon, but it can happen. I think, Your Honors, as well, in terms of our courts specifically giving a little bit of exception to standing issues, I can analogize to the family law arena, and there's a case in the family law realm called Houston versus Houston, and that dealt with procedural rules and the court's ability where children's best interests are at play to kind of deviate from what would be a rigid traditional application of standing or procedural rules.
You have a cite on Houston v. Houston?
Yes, I do, Your Honor. It is 64 Mass App Court 529.
Thank you.
And I think I can actually, I did bring it with me. I can quote, and I think.
I'll read it. Thank
Okay,
you.
I can quote a little. Thank you, Your Honor.
Appreciate your answer.
So I think in these particular kinds of cases where they're child custody involved cases, similar to domestic relations cases, in terms of the children being able to raise the issue of their father's counsel being stricken, I believe in our fact pattern, our joint briefs, we did note what was going on in terms of the children's wishes versus their representation. So the standing in those situations would delve into that kind of equitable ability to allow in this particular instance where father was not provided any counsel at trial to allow the children to assert that argument, where their lower court trial attorney wasn't able to assert maybe an objection or file a motion to continue.
We'll take a look at the cases. Thank you.
Thank you, Your Honors.
Thank you very much. All right.
Good morning. May it please the court, Attorney Deborah Dow, and I represent the father who is listening in on the YouTube link this morning. This case is rife with due process violations. I'll address two of those, the first of which was briefed by Child 1, but father adopted this argument in his conclusions. The decision to allow father's attorney to orally withdraw the morning father was facing the termination of his parental rights with no notice to father and no opportunity for father to obtain successor counsel should be reversed as an abuse of discretion by the trial judge. There are significant due process and liberty interests that attach to these proceedings. The judge failed to consider the manifest prejudice that father would suffer by proceeding with the trial without counsel for father. It is not unusual or out of the ordinary in care and protection cases for the judge to deny an oral motion done on the first day of trial. The judge not only abused his discretion in allowing counsel to withdraw, but also abused his discretion because father did not waive his right to counsel. At no point did father knowingly and voluntarily surrender his right to be assisted by an attorney. And yes, we acknowledge that father failed to appear on either of the 2 days of trial.
Did he attend any of the scheduled court dates?
He did. He actually attended the 72-hour hearing, the emergency custody hearing. His counsel did not appear for whatever reason. That's in the record. Father prevailed, and the children were returned at that point. Father's failure to attend the trial does not constitute a waiver of his right to counsel. A valid waiver of counsel must be voluntary, unequivocal, knowing, and intelligent.
So can I ask you, what do you think should have happened? Is the lawyer supposed to represent father's interests when he or she doesn't know what father's interests are?
Well, I think in this case, there was no indication that counsel did not know what father's interests were. Father had an interest which was represented at the 72-hour hearing.
She said repeatedly, I have no instructions, I have no information to the judge.
Right.
That would suggest that she did not know father's position and could not make arguments on father's behalf.
I think it was also clear that father was visiting at that point in time, and he had been visiting for several months prior to the trial commencing. I think at a minimum, the judge should have inquired further to the extent of what contact have you had with father, what efforts have you made to reach out to father, and do you have any understanding that father has changed his position? And that is common in these cases. And father did not abandon these proceedings. I'll address DCF's argument. They argue that he did abandon these proceedings. They cite to adoption of Marina. However, I would suggest that in adoption of Rory, this court found in a similar fact pattern to this case that the father did not abandon the proceedings despite not appearing at trial. And I would suggest further that this case is more aligned with Rory than it is with Marina because of father's not just engagement in past proceedings, but father's engagement in the 6 or so months leading up to the trial. He had met with the department, he had visitation, and that visitation went extremely well. According to the reports that were submitted by CASA that are in evidence, the children respond to him. and they respond in a positive way. I also want to add that DCF argues under Marina, but that the judge made no findings under adoption of Marina, as the department suggests, that father abandoned the proceedings, to the extent that the judge had any ability at that point to discharge counsel. In fact, the evidence was to the contrary. The counsel he had at various times throughout these proceedings, so he didn't even have counsel throughout the entirety of the proceedings. And counsel was reappointed for him just a few months before trial when it became apparent to the court that father was visiting. To pile on, I'm sorry,
Your time is actually up.
sorry. I didn't see that, Your Honor. And I would just ask that the termination be deemed void due to the lack of due process. Thank you.
Thank you very much.
May it please the Court, Jeremy Bailiffs for the Department of Children and Families. There are a number of due process arguments that were raised, so I think it probably makes sense to start with those. With regards to Mother's counsel, Mother had been proceeding pro se for months prior to trial. She had begun pro se in January. Trial didn't happen until November. She received multiple colloquies. There was no indication that she lacked the capacity to understand what trial was. The mental health allegations that are raised and were properly considered by the court are due to her volatility, due to her aggression, due to her violence. And as the case law makes clear, the mental competence evaluations are done in the context of what's being evaluated for. You can be mentally unwell.
I'm going to ask you to speak up a little bit.
Oh, I'm so sorry.
Okay.
You can be mentally unwell, but still competent to make the decision to represent yourself, which is what happened here. With regards to father's withdrawal of counsel.
Let's go back to the
Certainly.
Mother's case. Counsel for Mother brought up the Halterwanger case.
Yes.
Can you distinguish that case from the present set of facts?
Unfortunately, not by name alone.
Okay. It's 99 Mass Ep Court 543, and I think that case discusses the need to make written findings regarding a person's competency in certain situations when you are allowing them to proceed without counsel.
Well, I mean, I think in these cases, the parents waive counsel relatively frequently without written finding. In this case, the judge in the record shows that there was a thorough evaluation, a thorough colloquy on multiple times, in which Mother was asked about. Mother's attempt to go pro se was briefly rejected at one point, so that she could have a conversation with the attorney who would be her standby counsel about what it would entail, and she came back and reaffirmed that that is what she wanted to do. And so
Still
we
having just a little bit of difficulty hearing you, because
I am so sorry.
That's okay. Well, the microphone is lower than you are, so
I
if you could
know.
lean forward into it a little bit, that would be helpful. Thank you.
I'll speak up a little bit, too.
That's good, too,
I get
yeah.
worried about yelling. And so I think we have a pretty thorough record from the transcript as to what Mother's ability was and was not, and what her wishes were and were not, versus hindsight reflecting on the efficacy of that desire. With regards to Father's counsel reported having no position from their client on July 20th, 2021, September 21st, 2021, January 14th, 2022, February 16th, 2022, May 18th, 2022, October 19th, 2022, and at trial. It had been well over a year, close to a year and a half, since counsel had had a position from Father, and since Father had attended any form of court proceedings. He attended the temporary custody hearing, but that was over a year and a half. And as this court's aware, as any court handling these cases is aware, parents can change their positions during that case. Requiring Father's counsel to remain on with a year and a half of no contact, no guidance, would be at best at risk of compelling an attorney to advocate in a position that is potentially contrary to what their client actually wants. Unlike Rory, father had not been participating in trial. This wasn't a case of he simply failed to attend trial. This is a year and a half of complete disengagement from the legal proceedings. The fact that he had renewed some visitation with the children in the months leading up, his visitation overall was still very sparse. But the fact that he renewed some visitation and had some contact with the department is almost an indication that it was a willful disengagement from the legal proceedings, because he knew that it was happening, he knew that he had a lawyer, and he knew that there was an ongoing care and protection proceedings that could result in the termination of his parental rights. He did not attend court dates, he didn't communicate with his attorney, and he didn't show up for trial. And so the record also shows that this judge really did as much as they could to ensure that father maintained representation, because counsel had been asking to withdraw well before trial. And the judge kept saying, give him another date, give him another date. And then we got down to the last absolute minute where counsel would have to either sit in the courtroom saying nothing, which would provide no benefit for father, or would have to guess as to what their client's position would be, which is also, at best, an ethically dubious obligation to take. The only outcome at that point, given father's disengagement, was to allow the motion to withdraw. Best practice may well have been more findings, more detailed findings there, but given the facts of this case, and given father's counsel's lack of a position direction from his client, or her client, there was certainly no prejudice, and there was no other outcome that could have happened there. With regards to, with regards to this, the plans for the children.
Excuse me?
With regards to the plans for the children, these were not the best adoption plans. This is not best practice for proceeding. There's no interpretation of the record that this is. Ideally, there would have been much more detail. But at the time of trial, between the court reports that are in evidence in the testimony at trial, there were identified potential resources for all 4 children. There was not a lot of detail, but there was sufficient detail, given that there was no competing plan introduced, and there was no real discussion of alternatives, for the judge to make an assessment that those plans were in their best interest, given that their permanency hearings are regularly scheduled, the children retain counsel and have the ability to go back into court if there have been changes in the developments, and so they were there. Nevertheless, if the plans were to be deemed inadequate, there is no basis for disturbing the termination decrees as to either parent on the basis of that lack of detail. This court can easily remand for additional findings as to the permanency plans, additional facts, without disturbing the termination decrees.
What's your best authority for the proposition that these plans were, as you say, although not the best, legally sufficient? What is your best authority for that proposition? Understanding it's a fact-specific analysis.
Off the top of my head, I don't have the case name. It's cited in my brief. For just the proposition that plans do not need to be written, they don't need to be detailed. They don't need to be written and extremely detailed. They need to be simply sufficiently detailed for the court to make an evaluation of what the best interest of the children is, and that can be based on testimony and documentary evidence, not a written plan. But even in the event that these plans were inadequate, this was a mother who was physically abusive to the children. She strangled one of them for a minute in the hallway. When she got conditional custody of that child and their siblings back, she allowed the younger boy, or I don't know, it was the older boy, the same child actually, to ingest cocaine.
Access to the drugs, yep.
Right.
We're familiar with that.
She continued to be violent. She continued to be aggressive. There was no indication that she was improving as a trial. As a father, he also engaged in the violent relationship with mother. There was no indication that he was remedying his parental deficiencies. He was engaging in some visits, and the visits went okay before trial. but he was not improving. Termination was appropriate and was necessary and was in the children's best interest, even if more need to be done as to the plans. If there's no further questions, I'll cede the rest of my time to my sister.
I see no further questions. Thank you very much.
Thank you.
Much lower. Good afternoon, Your Honor. Jennifer DeFeo on behalf of the minor daughters. For ease of reference, I will refer to them as older daughter, and younger daughter. On their behalf, we are asking that this court affirm the lower court's decision to find their parents unfit, to terminate their rights, and to approve the adoption plan. I would like to speak to the adoption plan a little bit more because I do think that is an issue in this case. I don't necessarily agree with DCF that it was not as sufficient as it should be, and the reason why is it was only raised by father that there was an insufficiency in the proposed adoption plans. And father has no standing to argue on behalf of the younger daughter. In matter of JSV, which is 402 Mass 571, it's a 1988 SJC case.
402 Mass 571?
Yes, sorry, a little too fast. The court determined that the due process of an unmarried putative father has no absolute due process right to notice an opportunity to be heard before a child may be adopted. And while it does say no absolute due process right, what we have here is a father who made no effort. He could have fought to have paternity established at any stage, and it wouldn't have been a true fight. He chose not to do so. His name was not on the birth certificate. So when he argued that the proposed plan for the youngest child was insufficient, he couldn't do so. He didn't have the standing. But his argument actually conceded that there was sufficient because he himself stated that there was some issues with her that needed to be addressed by whoever were to adopt her. He indicated what his statements were, actually, I quoted them here, is that there's an identified adoption resource, a cousin who lives in Virginia who has expressed an interest to apply to be a placement for her, and that the adoption plan did contain additional information. The social worker who testified indicated that the child receives early intervention, she has occupational therapy and speech therapy, and that's a trial transcript 328 and 329. The adoption plan, first of all, doesn't have to be fully developed. This meets the core requirements. There's been somebody who has inquired. These are the specific things that this child needs. As for the older child, who father does have standing to argue, he said, I'm okay with the adoption plan. The paternal aunt was the adoptive placement. She was the one who has been the pre-adoptive parent for a significant amount of time, and the child is doing well in that position with her. I believe that's all I had on the adoption plan. If you'd like, I can move on to some other issues. The motion on the mother to argue that she could not waive her right to counsel because of her mental health. There are cases that cite the Haltwanger case, and they call it now a motion for a Haltwanger issue, where trial counsel, if they believed that there was an issue with the mother's mental health, would have had to state so. And the attorney who was involved as trial counsel was a seasoned attorney. If she had reason to believe that mother could not assert her waiver because of a mental health issue, she would have had an obligation to report that to the court, and she didn't do so. And as an officer of the court, we have to assume that she would have done it. And there is case law that says that an officer of the court does deserve credit based on their status as such.
You would agree, though, that even if counsel doesn't bring that to the judge's attention, if the judge hears something that mom says that raises an issue of competence, the judge has an obligation to explore that.
Absolutely, and he did do so, Your Honor. What he actually did is satisfied under the law, which states that he has to determine her competence, and it's this court to look at it as an abuse of discretion. So it would need a standard of review that is quite difficult to show that this judge abused his discretion when he had repeatedly and consistently throughout these proceedings spoken to her, asked her questions, she answered them, he asked her other questions. He rephrased the questions just to make sure she wasn't just yesing him, and that's how I read that. So I do think that she did knowingly, voluntarily, and competently waive her right. I do see that my time is just about over. If there aren't any further questions, I will rest on my brief and ask that this court
Seeing
affirm.
none.
Thank you.
Okay. Thank you very much. We appreciate your arguments, and we'll take the case under advisement. Okay. Our next case will be Mark Aldana versus the Commonwealth, 2023-0099. We'll just take a moment until the courtroom clears out, and then we'll address the case. Okay. We've received a communication from Mr. Aldana just a little while ago who said he's unable to come to court today. So he is representing himself pro se. He's not going to be here. He lives about an hour away and indicated he had car trouble and made it clear that he wasn't going to appear. So he will be resting on his brief, and we will hear argument from you, Attorney Vail.
May it please the Court, Assistant Attorney General Hannah Vail, on behalf of the Commonwealth. I'm here with my co-counsel, Marianne Reynolds, who is also trial counsel in this case.
I'm going to ask you before you even start your argument to pull that microphone a little bit closer to you and talk into it so we can hear you well. Thank you.
Is this better, Your Honor?
Much better.
Thank you. The Superior Court correctly instructed the jury in this case regarding the elements at issue based on the evidence that was presented. Mr. Aldana has challenged essentially three categories of jury instructions in this case. The first concerning the lawful authority element of the incendiary charges, the second concerning the intent element of the incendiary charges, and the third concerning the related crimes instructed under the Chapter 258D framework, which the jury never reached in their deliberations. Turning first to the lawful authority element, as an initial matter, there's no ex post facto issue here because this is a civil case that Mr. Aldana has chosen to bring. Drilling down into the specific regulations that he objects to, the flammable solids regulation was correctly instructed in this case because unlike in the underlying criminal case, there was an expert that testified that both aluminum powder and thermite constituted flammable solids. Mm-hmm. Even the regulations themselves reference industry standards for aluminum powder, which indicates that the aluminum powder should have always been considered a flammable solid.
You know, I lost your last phrase there because we really need to have you talking to the microphone so we can hear you as well as the public can hear you, okay?
I apologize, Your Honor. I just said that the applicable regulations explicitly reference industry standards for aluminum powder, which indicates that the flammable solids is correctly being applied to the aluminum powder in this case. The judge also correctly refrained from instructing the jury regarding the weight limit exemption for explosives because that exemption applies only to special industrial explosive devices. Unfortunately, the regulation does not define that term, but based on the plain language, it should be something that's used in an industrial context, and it should be a device. And neither of those factors is present here, where Mr. Aldana mixed the powders in his kitchen, and it's just a bag of powders. Regardless, even if there was some issue in any of the regulation instructions, there was no prejudice because there are multiple other avenues by which the jury could have concluded that Mr. Aldana lacked lawful authority. Mm-hmm. For one, the jury was instructed that under Chapter 148, Section 24, no building can be used for storage of material that should be a fire menace. The jury also heard testimony from Mr. Mansfield that hazardous substances shall not be left unattended in a building without a permit from the fire department. It's uncontested in this case that no permit was obtained by Mr. Aldana, and therefore the jury could have concluded that he lacked lawful authority, and the judge was correct to issue the instruction instructions in this case. Turning to the intent element of the incendiary charges, Mr. Aldana requested an instruction that intent to make a weapon is an element of the incendiary charges, but that is not reflected in the language of the statute. It draws from a footnote in the SJC opinion, which refers to a federal statute that does use that language. The judge correctly instructed the jury according to the state statute, using the language designed or adapted to cause physical harm to persons or property. The judge also correctly instructed the jury regarding consciousness of guilt because there is ample evidence of both concealment and flight in this case. At the time that Mr. Aldana objected on the 6th day of trial, that instruction had already been issued twice previously without objection, and Mr. Aldana had himself first used the phrase consciousness of guilt before the jury.
I'm not sure I've ever seen a consciousness of guilt instruction provided in a non-criminal case before. So that begs a few questions for me. One, is there any precedent for giving it in a 258D case? That's my first question.
Unfortunately, Your Honor, there's not. I believe there's about 13 published cases about 258Ds, and based on my research, none of them stem from a trial. They're all motions to dismiss or motions for summary judgment. So the judge here was essentially operating in a vacuum.
Have you ever are you aware of a consciousness of guilt instruction being given in a different civil context, for example, in an SDP case or a SORB case?
I'm not personally aware, but I wouldn't be surprised in that context. And I think in this case, 258D presents a sort of complicated scheme for the jury to conclude, where you're considering the prior criminal charges and deliberating about them using a different standard of proof. So I do think the consciousness of guilt instruction is appropriate here, where the jury is considering whether a crime has been committed, albeit in a civil context.
You just raised a very interesting point. There does not seem to be a lot of cases providing guidance as to what is and is not admissible in a 258D trial, and what sort of what the framework actually is of such a trial. What is the lead case that exists right now that delves into that?
I would say, again, there's nothing exactly on point. I would say the language of the statute supports that directly. I would say the Guzman case, 74 Mass App Court 474.
Could you repeat that?
Please, sir, it's Guzman v. Commonwealth. It's 74 Mass 474, and it talks about the obligation to prove actual innocence. I would also say there's a Cruz case out of this court that talks about related crimes. That's 102 Mass App Court 689. That's before the SJC right now, but the existing case law does talk about the need to demonstrate that you did not commit the crime charge or any other related charge.
Has Cruz been argued before the SJC, or is it?
It's been argued, and I believe supplemental briefing has been issued, and we're waiting on a decision.
Interesting. Thank you.
Turning to the related crimes framework more broadly, as an initial matter, the jury never reached these questions, so it's not necessary for this court to reach them as well. If you look at the jury verdict slip, the jury clearly concluded that Mr. Aldana had not met his burden of proof to prove by clear and convincing evidence that he did not commit the crime for which he was originally convicted of. They never reached any of the other things, and therefore he cannot show that he was prejudiced by any of these other instructions. Regardless, the instructions were correct because it mirrored the language of the statute. Under the statute, Mr. Aldana has to prove that not only that he did not commit the crimes or crime charged in the indictment or complaint, but also that he did not commit any other felony arising out of or reasonably connected to the facts supporting the indictment or complaint. And Mr. Aldana's interpretation completely writes out that second clause in an impermissible way. Here, all of the related crimes that were instructed are arising out of the same facts. They all concern Mr. Aldana's possession of aluminum powder, iron oxide, and thermite on October 15, 2013. Mr. Aldana has only raised objection as to two of the related crimes, the burglarious tools crime and the evidence tampering crime. And there's evidence to support an instruction as to both of those. As to the evidence...
How is a possession of burglarious tools related to the to the crime that he was charged with?
The Commonwealth's theory was that the thermite was being made for the purpose of being used in a burglary. So Mr. Aldana had testified that he intended to use it. Well, he had testified that he thought it would be cool, and that's why he had it. And there was also testimony from experts that there are a limited number of uses of thermite. And during the trial, they systematically eliminated all the lawful explanations to have thermite, such as welding, such as railroad work, such as military service. And then so all you're left is this contention that he had it because it was cool. And in that vacuum, and there's also testimony that thermite can be used to break into a lock or a safe. And that's the only one that was not addressed, that's not disclaimed by Mr. Aldana. It's also...
What was the evidence that he wanted to break into a safe?
The evidence...
It was more of an exclusionary piece of evidence, in a sense, because they couldn't figure out why else he would have had it.
There's that, Your Honor, and then if you look at the pattern of his prior and subsequent conduct, the jury heard evidence that suggested at least an inference that he had committed a progression of criminal acts. The first is obscuring a plate, then receiving stolen property, then larceny, and then this instant with the thermite, then a breaking and entering, and then a home invasion. So looking in this context, you can see an escalation of behavior over time, and that helps fill the gap of we have no reasonable explanation as to why he has this substance, and it can the only remaining use is used to break into a lock or a safe.
Sounds a little bit like propensity evidence, doesn't it?
I understand the concern, Your Honor, but again, there's no prejudice here because the jury never reached this issue. And I would say that's the primary concern.
Well, it's fair to say they didn't reach the issue given the special questions on the jury for form. But what effect would that have? Are you saying that particular evidence had no effect whatsoever on their deliberative process?
I would say that it cannot have a substantial effect on their deliberative process where there's overwhelming evidence that he did not meet his burden of proof as to the incendiary charges. There's evidence, he testified that it was his powders, he testified that he intended to make thermite, he knew it was dangerous, he didn't have a permit. There's testimony from his own expert that the only possible reason to have this was as a destructive device. There's evidence by fire officials that this was hazardous and dangerous, and so even if the admission of the other bad acts had some impact on the jury's deliberation, I don't think it has any substantive effect given the weight of evidence against Mr. Aldana here.
There was no limiting instruction whatsoever regarding these other crimes that he was questioned to by the judge, correct?
There was in the closing jury charge, Your Honor. I believe it is at transcript number 6, 52 to 53.
And what was the jury allowed to use the evidence for, though?
I believe the instruction was that you're allowed to use it in terms of burglarious intent, but that you're not allowed to use it for the classic character evidence as propensity as to proof that he is a bad person. And I think that limited instruction also helps curtail the effect that these related crimes had on the jury's deliberations.
But I guess to follow up what Justice Nyman said earlier, if the evidence was being introduced to show that he might want to commit a burglary, isn't that exactly propensity?
I don't think it is, Your Honor.
How did the limiting instruction that the judge gave prevent it from being propensity to commit a burglary?
The judge limited how the jury could use it in terms of you can't use it as just a general impact on his character. However, and then, as I said, that they limit it to the burglarious intent. I think that the overall picture here is that although that this evidence was produced, this has really no relevance as to whether he proved his burden as to the incendiary charges, which is what the jury rested their verdict on. And therefore,
Can I ask you about a side thing, which is the Commonwealth questioned Mr. Aldana about acts that were dismissed. That would normally not be admissible. So tell me why it was admissible in this case.
I believe they are questioned about charges that were quaffed.
Which were ultimately dismissed. That's
Yes,
what
Your
a quaff
Honor.
is. So they were dismissed.
Yeah, and I think similar to how in a civil case you can draw an adverse instant inference from a Fifth Amendment, taking the Fifth Amendment, you can similarly take an adverse inference when someone has admitted sufficient facts that they could be found guilty. That's relevant to the issues here, and the Commonwealth was entitled to inquire about them here.
What is your best case for that?
As to the
Because there are different types of admission to sufficient facts. And my recollection of the transcript was the lawyers didn't question him about how the admission was. Was it admission that there were facts sufficient, or was it admission that the facts were true? Those are two different concepts under a continuance without a finding, right?
I believe so, and I don't believe that's the distinguishment is in the record here. I think the Commonwealth acted in accordance with the judge's motion in limine order, which allowed them to ask only, is there sufficient evidence? Did you admit sufficient facts as to insert crime? And so the Commonwealth was complying with the motion in limine order in that way. To answer Your Honor's question about the best case, I would say by analogy that the Fifth Amendment adverse inference would be Lenz v. Metro Properties, 437 Mass at 26. And I think that the other case would be just the proposition that the judge has wide discretion in determining whether something is prejudicial versus probative. And I don't believe that the judge abused her discretion here in this context where intent is a required element of the burglarious tools charge. That's properly instructed under the 258D framework. And the judge created a motion limine structure that carefully limited the types of crime that could be inquired into, what types of questions could be asked, and issued a limiting instruction. I think in this case, there's no abuse of discretion when considering all those factors in totality.
I see your time is up, so I'm going to see whether or not there's any additional questions. There's not. Thank you very much.
Thank you. I'll rest of my briefs.
Okay. The next case I'm going to call only by number because it is impounded, 2023-0255. I'm sorry. Just one moment.
Mind if I go?
Go ahead.
Before you begin, I just want to make sure your client submitted a brief pro se, is that correct?
Yes, Your Honor.
Okay, and did you file an appearance to argue before us today?
I did.
Okay. And may I ask when you filed that? I'm sorry, I just don't have it here on my iPad. That doesn't mean that it wasn't done. I'm sure it was if you make that representation. Around when? How long ago did you file an appearance to come and argue?
It was, my initial appearance in the case was in the spring of this year.
In this court?
In this court, yes.
Okay. Very good.
And then I notified, when we got the notice of the oral argument, that I would be appearing. And I did actually have some discussion with the clerk's office about the fact that I had previously filed an appearance after the brief was submitted.
Okay.
And frankly, I was told that would be sufficient.
It's fine by me.
Yeah.
Thank you.
I'm sure it is, we just didn't have it, so we were double checking. All right, yeah.
Yes.
Just housekeeping question, that's all.
I appreciate it, thank you.
All right. And
May
good
I
morning.
proceed, if I may
Yes.
please the court? Bruce Kraft, I'm arguing the case on behalf of the plaintiff, who is I will refer to her as the mother of the child, who's the complaint for modification, or complaints for modification, were the subject of the probate and family court proceedings concerning this case. The sole issue at this point in time and purpose of this appeal is an order that was entered by the trial judge following trial and pursuant to a submission by the father defendant for an award of attorney fees to be awarded in this litigation, which the court entered an order of attorney fees. I believe it's in the amount of $18,975 for the defendant. The underlying complaints for modification have essentially become moot.
But the only one that was at issue in trial is the June motion for modification, correct? That the trial was on the June motion.
The
trial itself involved the June motion for modification, correct? The one filed in June.
Well, what complaint, Your Honor?
Yes.
It was a complaint that was subsequently amended.
Correct.
It did concern two complaints for modification. They were consolidated. I believe the record
Okay.
does show that.
So
was
the
a-
only issue before us now, you would agree, is the attorney's fees?
Yes. And I'm just by way of background, the case, if you will, the consolidated cases for modification began in 2019 when the child wasn't yet 3 years old, but the issue involved where the child, or if the child, would be attending preschool. I would suggest to this court a very important part of a child's life is the preschool. It's become more than just babysitting or daycare.
I read through all of the entire record, the motions for modification, everything, the entire history of this case. And my sort of background fundamental question for you is this. Although captioned as a modification motion, although styled as such, it appeared to me this was more of a motion for contempt. The motion really stated, look, father's not abiding by settlement agreement, right? He's not abiding by, or the separation agreement, rather.
Right.
The child is not, we can't reach agreement, or he's unwilling to reach agreement on the school, on the preschool. He's unwilling to ask the coordinator or the arbiter to, as the separation agreement provides, to help us through this situation. All of that strikes me more as a proceeding in the nature of contempt, not modification. Am I wrong about that?
No, you're quite frankly absolutely right, Your Honor, because that's how we started, and I represented Mother throughout the proceedings, at least, I wasn't her initial lawyer in the divorce case.
And there was a finding of no contempt, and that sort of led to a bunch of modification motions being filed.
We took the position, Mother took the position that the language in the separation agreement, which was adopted as a judgment of the court in the judgment of divorce, mandated that the child would attend preschool. The judge, same judge who heard this modification, interpreted the agreement otherwise and suggested that it was not a clear and unequivocal order and did not find the defendant father in contempt for not cooperating and not permitting the child to attend preschool, but in his very order regarding the contempt suggested that a complaint for modification would lie and was appropriate because there was a substantial change in circumstances. There was a change in circumstances from the parents agreeing that the child would attend preschool, anticipated when the child turned 3 years old. And that single word, anticipated, hinged on whether he was in contempt and there could be an enforcement order or whether a modification had to be filed. And so the trial judge suggested that a modification was appropriate. We filed the complaint for modification. We filed the complaint or strike that, a motion for temporary orders because it was time sensitive. The child was going to be turning 3 years old and would be eligible to attend a particular preschool.
So we know the facts and we know the history. Let's cut to the chase. Why did the judge err in awarding attorney's fees?
Well, what our argument is at this point in time, particularly regarding the complaint for modification regarding preschool, is that, with respect, the trial judge got it wrong. The trial judge should not have dismissed the case.
Should have let it go to verdict.
The trial judge should have let the case go to verdict. He dismissed it after the plaintiff rested, saying that there was not sufficient evidence to permit the modification, either modification, and what is particularly puzzling on mother's behalf is that the language in the separation agreement, which established what the party's intention was that the child would attend one preschool, which I suggest you don't need an expert to figure out that a child of that age attending one preschool makes a lot more sense than a child that age attending two different preschools. But again, the record is complicated. I probably don't need to repeat it, but during the course of pretrial proceedings, there was a great deal of effort made by father to change the court's initial temporary order. The child will attend one preschool. It is one the child has been accepted to. It is the one that is in the town of Brookline, and the father will pay for that.
But then that changed later on.
Pay 50/50.
And again, I still don't have an answer, haven't heard an answer to Justice Nyman's question about the attorney's fees. What the legitimacy of, what your argument is about the attorney's fees.
The argument is, with respect, I would hope we can agree that if the trial judge was in error and should not have dismissed the case and allowed mother's complaint for modification, which said we're only going to be sending the child to one
So your point is that
preschool.
error triggered further litigation? Is that your point, for which the mother should not have to be paying for the father's attorney's fees?
If generally, and I would suggest we would agree that the losing party does not get awarded attorney fees.
So let me ask you this.
So,
I'm
Hold on,
sorry to
there's a
interrupt you.
question. There's a question.
Let me ask you this. Would you agree with the proposition that even if you show that there is, at the motion to at the dismissal stage, at the directed verdict stage, what have you, that there's a material change in circumstances, that there could be, that the record would support that, then the case should go to verdict, correct?
correct.
Okay. Just because it goes to verdict, though, does not mean that the judge is obligated to allow the modification, right? A judge can say, yes, there's a material change in circumstances, but I think the best result is still to keep the terms of the separation agreement or to keep the current status quo, right? Simply because
Judge
there's a
has
material
that right
change
to
in
do that, yes,
circumstances
I agree.
demonstrated does not require the judge to rule in your client's favor, ultimately, right?
Right.
Okay.
But I, again, as has been argued by my client in her pro se brief, and I believe as the record shows, the judge's rationale, both pretrial and in his order, was the phrase, mother is being litigious for the sake of being litigious, as if she got some, there was some motivation other than what I suggest is crystal clear. The motivation was what is best for the child. And it was, in her view, it was best for the child to attend preschool as the parties had agreed to when the child was nearing her third birthday. She would be 3 in September of 2019. She's almost 8 years old now. And the judge seemed to be changing his viewpoint as the case progressed, because initially he was very clear, child should be attending preschool. He allowed our motion for temporary orders.
Counsel, I guess I'm doing a follow-up. What's the abuse of discretion in awarding the attorney's fees? The case law is a judge doesn't even have to find bad faith in awarding attorney's fees. I think it's
Under
possible.
20838 in the case law, yeah.
So if a judge doesn't have to find bad faith to assess attorney's fees, how is this an abuse of discretion?
And I suggest the answer is because pre-trial, the trial judge indicated that if he believes there is good faith on the part of a litigant seeking to modify a judgment which would be better for the child, he would not award attorney fees. And we took that to heart, that we are proceeding, particularly regarding the school issue, on the basis that one preschool for this child and the preschool that she had been attending was the most appropriate order. And we frankly believe that the judge should have followed the party's initial attention. There is case law that should have been given great weight. He should have analyzed what the agreement was, the separation agreement, and the way that it was worded, that this child was going to attend one preschool, rather than during father's parenting time, she can go to a different preschool than the preschool during mother's parenting time. And that issue was litigated by both sides, yet mother is being litigious for the sake of being litigious, but father, who is objecting to
interrupt for
what
one-
mother
there's
is
one more
doing
question from
is
the
not
side.
being litigious. It
So-
frankly was,
Just one moment, please. There's a question for you.
I apologize.
I don't apologize.
problem.
We're interrupting you. So my final question is this. It's a hypothetical. I want you to assume that instead of dismissing the case, the judge denied the motion to dismiss and instead rendered a verdict in favor of the father. Exact same set of facts, exact same thing happened at trial. Judge denies the motion to dismiss, renders a verdict in favor of the father immediately thereafter. Under that circumstance, was it within the judge's discretion to award fees to the father under 208-38?
There is discretion under this statute. And hypothetically, if the case had turned out in the fashion that Your Honor just suggested, the judge could have acted in that fashion.
So your argument hinges on the fact that the judge wrongly dismissed the case rather than waited 10 seconds and rendered a verdict?
I'm suggesting that the judge, if he had waited to hear all the evidence, or even if no further evidence was submitted, he should have found in favor of mother and granted her complaint for modification and entered a modification judgment, and then
Okay.
maybe would have awarded mother attorney fees rather than awarding father attorney fees. But as I said at the beginning, we can't ask the court to remand the case to the trial judge to rehear the issue of which preschool the child will attend because the child's now in second grade.
I understand. Thank you.
All right. No further questions. Thank you very much, sir. All right, Counselor?
Good afternoon, and may it please the court. My name is Kelvin Heinley, and I represent the father. And if it's okay with the panel, I'll continue to use that moniker,
Yes.
given the status of the case. Justice Naiman, what you just brought up helpfully derailed where I intended to go out of the gate, because the hypothetical you just posed turned out it actually wasn't a hypothetical at all. As the panel I'm sure will recall from the record, during this appeal, issues were brought to this court by mother as to whether she could proceed on both a new modification that was pending before First Justice Dunn and this appeal simultaneously. Your honors chose to allow her to proceed with that appeal because she informed this court that all she was arguing was actually the fees award and not the underlying merits. We just finished the litigation of that second modification by mother on the exact same principal issue, which wasn't preschool. The real issue here was she was attempting to overhaul the shared parenting plan that they had agreed to, which I would respectfully suggest has far more importance and long-term implications than just a choice of preschool issue. Justice Dunn went to trial. Mother rested her case. He looked at me and said, "Do you intend to present any evidence?" Same question that was posed to my predecessor several years before. I took my client out in the hallway. We had a brief discussion. We decided not to present any evidence, and we rested. Instead of dismissing on 41B this time around, he said, "I'm going to take it under advisement. I'll think about it." We got the decision a few weeks later denying mother's appeal, and this time he chose not to award fees in his discretion. So that actually wasn't a hypothetical at all. He just did that very thing. And what I was going to tell this court was, if we step back from this case and look at the variety of ways in which First Justice Dunn had the authority to award the father fees here. Some are statutory in nature, some are common law in nature, but the point is this. First Justice Dunn had the right but not the obligation to grant mother an evidentiary hearing, a separate evidentiary hearing on the issue of fees. When this discussion happened on the record, as you'll see from the transcript, mother's counsel, my brother, didn't ask for a separate evidentiary hearing. There was a discussion of how and when they would argue it on the papers, and that's what they ultimately did. But even if they had asked for a separate evidentiary hearing, I don't believe the law requires Justice Dunn to hold a separate hearing because, as Justice D'Angelo pointed out, he has the discretion to do that here without even reaching the bad faith statute. We don't need to get to 231-6F. In the probate and family court, we have 215 Section 34A. We have 208 Section 38. We have Wasson and its progeny that's cited. There is every single day, there are myriad ways in which probate and family court judges award fees to people. Pendente lite under 208-17, on a contempt filing that was argued on oral representations of counsel, as an advance against the marital estate under Section 34. There are a myriad of ways Justice Dunn had the authority, but in particular under the Section 38 contempt statute, that does not require a separate evidentiary hearing.
Well, let me stop you right there. Here's where I'm struggling. At the dismissal stage, even at the end of trial, we're supposed to look at the evidence in the light most favorable to the non-moving party, correct?
I would concede that for this, sure.
Okay. So I want you to assume for the sake of argument that under that standard, there was enough to support a finding of a material change in circumstances here based on the history of this case.
Yes.
Okay? So you have to further assume then that the judge erred in dismissing the case rather than rendering a verdict. It was pretty clear where he was going with the verdict, but let's assume there was that mistake. With that in mind, if the judge made that error, does that render the award of attorney's fees null or void? If so, why? If not, why not? Do you understand the question? Because it's a difficult one.
A lot of assumptions, but I do think I understand where you're going with it. And again, that goes back to what I said at the outset of my argument, that we don't even have to imagine that hypothetical, it just happened.
Well, it sort of happened at trial because there was the conversation and the judge said, look, he said, so would you want me just to wait until verdict and do this? No, I'm going to dismiss it.
Yep.
But let's assume the judge made a legal error in doing that. What then?
Well,
how can he still award fees?
Yeah, so he has the authority to award fees at various stages well prior to verdict in the probate and family court. It can be done on a temporary order basis. It can be done pendente lite, even on a modification. So I don't think you need to wait for a so-called verdict to render fees at all. And in fact, it happens often at various stages, even on modifications in the probate and family court. So I don't think there's any support for the idea that a verdict, a judgment, in our words, as a non-jury court, would be required prior to getting to the issue of fees. It happens every day, pendente lite, or as a matter of an advance for somebody who has been so litigious that judges can even award fees on a modification or on an appeal for that person for a serial litigator. And what I would suggest to this court is if we take a step back and look at all the different ways that Justice Dunn actually tried to protect the mother on this fee award. He awards $18,975. He breaks it down into $125 a week over almost 5 years, or a number of years. He charges no statutory interest on that, and it was less than 20% of what my client spent with predecessor counsel. So he doesn't just blanketly award every dollar he spent. He doesn't run statutory interest, which he could have done. He doesn't order it due as a lump sum. He gives her every single opportunity under the law and waives certain remedies available to the father in favor of the mother. He even stays that order when she brings this appeal, even though she's simultaneously litigating another modification that she's now also appealing. He does all of those things for her. And in the 3 years that have followed since the entry of that order, she has not paid a single dollar yet.
But the basis for the judge's award here is the supplemental judgment issued on March 5th, 2021, correct?
Agreed.
And the supplemental judgment states that after due consideration of all evidence presented at trial, court finds that mother has failed to prove a material and substantial change sufficient to warrant a modification of the current judgment, and then awarded attorney's fees. By dismissing rather than waiting to make an ultimate determination, does that impact the award of fees?
I think no, because the father...
And I'd love some authority for that proposition.
Sorry, I cut you off. I thought you were done. I apologize.
What legal authority allows a judge to do that, again, assuming he erred in dismissing?
So the answer to that question, I believe, is that father and his then counsel, my sister predecessor, stood up and said, we are offering, like that they were in a position to offer no evidence, just like we did this time around this spring. There was nothing else to wait for. Father wasn't going to call a witness. Father had no burden. It was mother's two consolidated complaints for modification. And this time, we stood up and said the exact same thing.
But I thought you said earlier, the judge still has the authority, even after a trial, after a finding after trial, to still award attorney's fees.
Absolutely.
So it really makes no difference, at least according to Wasson and the statutes, whether it's after a dismissal or after verdict.
So
correct?
I don't think it makes a difference. I was attempting to tease out the hypothetical, but I think he had the authority at any point in time, whether he called it a dismissal or a judgment. You all have used the term verdict as a non-jury litigator. It's a judgment.
That's incorrect nomenclature on my part.
My point being, whether it was at a dismissal order or a judgment order, take your pick. He has the authority to do this both statutorily and under common law with Wasson and his progeny.
Let me see if I can tease something out of opposing counsel. Seems what he's arguing is, if there is a good faith basis to bring the modification, under that circumstance, a judge should not issue attorney's fees.
And if the Wasson court had said that bad faith was required, I would agree with my brother, but we know that that's not the standard. You don't have to get to bad faith.
Well, you don't have to get to bad faith, but I don't think it's ironic that the trial judge used the exact language from Wasson, litigious. That maybe isn't quite bad faith, but it has a nomenclature that's not a good nomenclature. So good faith to me is a judge could find that even though, again, whether it be dismissal or judgment, there was good faith in bringing the claim, but you lost. Under that circumstance, are attorney's fees warranted, or is that an abuse of discretion?
So I think that where Justice Dunn, I would agree with you, not coincidentally perhaps used the nomenclature from Wasson, that what he was referring to, and he puts this in his own findings, is at the pre-trial stage, this is in my brief, he warned everyone that attorney's fees were on the table because he had already given his feedback on the case, which in the probate and family court, the pre-trial hearing, I always tell my clients, is the most important day other than a trial. It's not like a check-in in the criminal district court. The pre-trial hearing is often 30, 40 minutes long, and it's a big, big deal. It's a preview of what's to come. And his prognostication was correct because the only standard, to be clear, on a request to change a custodial arrangement or a parenting plan is not just whether a material change has occurred, it's whether it would be in this child's best interest. And so one of the other places where that comes up is you represent someone who loses a job, files a modification saying, I can't afford to pay child support or alimony anymore, and the judge says, I recognize a change has occurred. You've handed me a letter from your HR showing you've been laid off. That's not the end of the analysis. Do they have assets to draw upon? Have they made good faith? So
this case would be so much easier to decide had the judge simply said, you know what? Regardless of the modification, I'm finding it's not in the child's best interests, and if we had that on the record, that makes this a much easier case.
And I think there's portions of his findings, because what's interesting to me about it, again, I wasn't my client's counsel at that time, when I read the decision, is he styles it a dismissal under 41B, but then entered pages and pages of findings and conclusions of law that I think that inference can be drawn from, that he didn't find that mother put on a case that would warrant any change that was in this child's best interest, either as to the preschool or the overhaul of the very specific parenting plan they had agreed to only a year or two before that was approved by that court, that was based centrally around my client's occupation and the unique nature of his schedule.
Do you disagree with counsel that at the time the contempt was filed and I guess ruled on, the judge invited a motion for modification?
I would respectfully suggest invited is the wrong word. I think he suggested it was plausible, but it always was. They're always going to be plausible. The thing about child-related issues in the probate and family court is the door is always open, as it should be. Things change and people bring claims. That doesn't mean it had to be successful. And as my brother pointed out, and I actually agree with this completely, Justice Dunn's thinking evolved as the case went on and the evidence came in. Good. Judges should have an open mind. Perhaps at the stage of the filing, at the end of the contempt, First Justice Dunn said, I don't know that this is a contempt, I think it's more of a modification. And then as the modification was prosecuted before him, he found it meritless. That's I would suggest a healthy way to operate on that issue. If there are no further questions, I can rest on my brief. And otherwise, the only other case I draw your attention to that I remembered this morning, because I argued it here as a first-year associate, and I forgot the numbers behind it, is El Shar versus Shihab, where Judge...
What's the cite on it?
And I'll get that to you, to the clerk. I didn't remember the numbers this morning, but I remembered the case name because it was a dismissal by Justice Dorothy Gibson of the Middlesex and Probate and Family Court on a 41B motion on a custodial issue, where she found there was a failure to prosecute, as opposed to going to judgment.
You can give us the name of the case and we can find it.
El Shar is
calling it like
E-L...
the numbers, you mean volume and page? Is that what you're referring to? When you
say
the numbers, are you referring to volume and page?
Yeah, I can get you the site, but it's El Shar, E-L space C-H-A-R versus Shihab, C-H-E-H-A-B. And like I said, it was Justice Dorothy Gibson of the Middlesex Court 15, 20 years ago, but it was a 41B ruling on a custodial issue involving a minor child, as opposed to
But this is a published decision you're talking about.
Say again?
This is a published decision. Okay.
Correct.
It deals principally a published appellate court decision.
Yeah, it deals principally with the issues of comedy from a Lebanese non-secular court, religious court, but it was the defense rested without presenting any evidence, and I think there's some correlation there, and I wanted to bring that up. That wasn't in my brief because that wasn't about fees; it was more about the merits of the procedure.
Okay. I see no further questions. Thank you very much. Thank you
all
both very much for your argument.
Your Honors, I may be totally...
There is no rebuttal.
I'm sorry?
There is no rebuttal in the appeals court.
I understand, but I suggest, I'm only going to state
There is
There's
no
no
rebuttal,
rebuttal.
so we really can't, there is no rebuttal, so we really can't hear what you have to say after the argument. That's the rules of our court.
You can file.
I
do you want to tell me you can file a
understand, but
16
I believe something is happening.
You can bring something to our attention with a letter to the court, under the rules, okay?
Thank you. I appreciate that.
Thank you. All right, we're now going to come to our last case, and our last case is also partially impounded, so I'm only going to call it by number as well, 2023-0946.
Good afternoon. May it please the Court, Attorney Deborah Dow, and I represent the respondent, Renee Albert. The respondent appeals the conclusion that a guardianship should have entered with the proposed treatment plan for 3 reasons. First, it was an error of law for the judge to find that the respondent lacked capacity to make informed decisions, particularly with regard to her medication. Second, the judge committed an error of law in closing the courtroom for a public proceeding. And third, the judge committed an error of law in adopting petitioner's findings almost in their entirety.
Counsel, my reading of the record is that the guardianship that is at issue expired, I think, in September of 2023. It may have been extended or there may have been a new one. But if it expired in September 2023, why isn't this appeal moot?
So my understanding from, and I did speak with DMH counsel just recently, is that the guardianship continues on, but DMH had intervened and filed a new petition.
So if it's a new petition, that means there's going to be presumably a new guardianship. So this one has expired.
This one, my understanding, has, because the guardian remains the same, this one has not expired, that they just intervened to then file a new guardianship. So that's my understanding.
Let me ask you this. If hypothetically it actually had expired and there was nothing further, would your position be different? In other words, would there have been any collateral consequences of what you allege was been an error when a guardianship has actually expired?
If the guardianship had actually expired, then, and there is a new petition that has been entered, prosecuted, the whole kit and caboodle, then yes, I think that there would be a mootness argument with respect to that.
Can I ask you called a housekeeping question? In the docketing statement that, excuse me, that you filed with the court, or at least that your client filed with the court, the appellate issue is listed as structural error due to closed courtroom Moffitt brief. So I guess my question for you is, this case was it filed pursuant to Commonwealth versus Moffitt, which is 383 Mass 201?
I did not file it pursuant to Commonwealth versus Moffitt. I did file basically a full brief arguing the 3 points that I just set out, one of the ones being structural error.
So you're asking us to ignore that reference to the Moffitt brief in the docketing statement?
In the docket sheet, right. So just briefly, to determine lack of capacity and being able to make informed decisions about her medication, the inquiry here is whether Ms. Albert was incapable of caring for herself by reason of mental illness. Essentially, that means, does she have a general ability to care for herself personally and financially? And I would suggest that she does. I think that there was testimony not just from the client, but there was testimony from the doctor as well. She had been able to attend to her own ADLs. She was a singer. She would play the piano on the floor. She would be able to, when she was living on her own, she would do her own shopping. She would do her own caretaking, attend to her own bills and pay her own bills. So I think that there is evidence that she was able to do these things. And while she was having delusions, and I think that's undisputed, delusions in and of themselves don't render a client incompetent or incapacitated. So I think in this sense, not only did she have capacity, but the second piece of that is whether or not she had the ability to make an informed decision regarding her medication. And I would suggest that she did. There was one medication in particular that she was not in agreement to take, which was Thorazine, and she had valid, legitimate reasons for doing so or for refusing. It would cause weight gain. It caused her stomach upset, and those side effects were certainly corroborated by petitioner's doctor that they called as an expert. So I would suggest that she did have the ability to make decisions regarding her medications, delusions aside. The second piece is the closed courtroom. The judge, it seems as if it was an issue of identity, protecting her identity.
I want to say it seems as if. That seems to be the problem here is we don't have any, there were pretrial transcripts clearly based on what the parties said. We don't know what the judge said pretrial. All we have is that one vague statement. For all we know, it could have been your client's lawyer who wanted the courtroom closed. Not that that would be the end of the story, but without those pretrial transcripts, how can we make such a decision on that?
Well, I think that the only decision made was at this particular juncture with respect to whether or not the courtroom should be closed. And I think there was a reference by the judge brought it up herself to suggest that we should close the courtroom for identity purposes. So I do think...
You mean, in other words, you want us to interpret that comment to be a sua sponte comment at the beginning of the hearing by the judge? Because to which there was no objection. I mean, it appears also to my view, and to Justice D'Angelo's point, that there was some discussion about this beforehand. I mean, neither party said anything about it after the judge made that comment.
Right, and there is no dispute that counsel for the respondent did not object to that. But a closed courtroom in a public proceeding, I would suggest there is a presumption of prejudice.
How do we know the lawyer didn't request it?
I'm sorry,
How do we know that your client's trial counsel didn't, or that trial counsel didn't request the closure
there's
of the
certainly no
courtroom?
motion that was submitted as part of the docket or that was entered on the docket to suggest that there was a request for a closed courtroom.
But what if there was an oral motion? It wouldn't necessarily be on the docket. What if it was done by agreement of all parties? I mean, I'm not, it's difficult for us on the record to make any assumptions. I don't think we can.
I understand. That said, I think that, as I said, I think that there is a presumption of prejudice, and I would ask the court to look at that. The third piece that respondent is arguing is the adoption of the petitioner's findings essentially in their entirety. While there were some changes that were made or discussed on the second day of trial as to the proposed treatment plan, the petitioner's findings were adopted almost in total. And there was, I believe, one change, a history of drug use, which was amended. But other than that, the judge did adopt those findings wholesale. And it's clear.
Anything clearly erroneous in those findings that she adopted or?
Well, I think that, yes, because there were some requested changes that the judge agreed to regarding the characterization of delusions, the issue that the clinician's affidavit had been entered, which it had been objected to and excluded pursuant to the law. So I think there were errors that were in those 4 pages of findings.
You mean in the proposed findings?
I'm sorry?
Do you mean there was errors in the proposed findings? Because those things were changed.
The errors in the proposed findings were then incorporated into the judge's findings.
All right, so then I misspoke. So you're saying that there were errors, and so that you're pointing to these things as being clearly erroneous?
It is.
Okay.
And as I said, I think what happens when those findings are adopted wholesale, or essentially in their entirety, is it really, goes to the integrity of the process. It makes the judge's decision, subject to scrutiny, and whether or not the proceedings were fundamentally fair. And, a litigant with mental health issues certainly deserves the same consideration as a litigant without mental health issues. And I would suggest to this court that that was error.
Okay.
Are there any further questions?
I see no further questions from the panel. If you have anything else you want to tell us, you may, but you may also rest on your brief.
And I would rest on my brief then. Thank you.
Thank you. Thank you very much. All right, that concludes our last case. The court will stand in recess.